Thank you very much. Good afternoon. So my name is Stephanie. My research is about competition law and sustainability. To share a little bit of my research with you, I would like to start with why did I decide to study that in the first place, since that's not necessarily an obvious intersection. What exactly I am researching and how I'm doing it, that's the methodology I am adopting. So first things first, why did I decide to study this? I want to take a few steps back into the Brazilian context, which is what led me to study this in the first place. So in Brazil, the federal constitution has a chapter on the economic and financial order. Just this chapter has an article that states the basic principles of the economic order. They're listed. And as you can see, there is, of course, free competition, but also there is social function of property, there is the pursuit of full employment, the reduction of inequalities, and environmental protection, okay? So there's basically two ways to look at this and to interpret this. The first one would be to say the competition authority has jurisdiction to protect competition, right? So it should stick to the free competition principle, which is listed here. A second possible approach would be to say the competition authority has, of course, to defend competition, but it should also take into consideration its analysis or decisions the other principles as well, since it is defending the economic order as a whole, okay? I'm not necessarily defending the first or the second. What I want to show you is CADE, which is the Brazilian Competition Authority, pretty much tends to focus on the first approach, okay? So in previous cases, CADE has already stated that it does not have jurisdiction to consider the other principles and to take these other aspects into consideration when conducting its analysis, okay? It does not have jurisdiction to do so, and there are other authorities that have more knowledge and also jurisdiction, of course, to conduct this analysis. This is what the authority said very clearly in a case ruled on 2019. It was a merger case involving Vale, which is a huge mining company acting in Brazil. It was buying Ferros, which is another company active in the sector. And I don't know if you're familiar with this, but Brazil has faced two major environmental disasters, both in the state of Minas Gerais back in 2015 and 2019. Basically, the disasters consisted in the collapse of two dams operated directly or indirectly through subsidiaries by Vale, which is the company I mentioned to you before, unleashing toxic waste and causing the deaths of many people. And why am I saying this? Because a federal senator took this case reviewed by CADE to court, arguing that CADE should not have unconditionally cleared that merger, allowing Vale to gather even more economic power in the country without revising and making sure it was compliant with environmental and social requirements. Whether you agree with that or not, well, the judge did, okay? And what the judge said is that CADE should have considered these factors. And the fact that it did not was a reprehensible offense. It even mentions that maybe CADE should be held accountable for not doing that, okay? This decision is not final yet, so parties have appealed that. CADE has appealed that decision as well, and that is yet to be decided. So, the Brazilian context now. Pretty much, as you can see, the competition law in Brazil does not mention specifically sustainability or environmental law or criteria, but the federal constitution leaves room for interpretation, right? Whether we agree with one approach or another. So far, CADE's decision emphasizes that it does not have jurisdiction on environmental analysis. However, in most recent decisions, CADE has indicated that that there is a pressure from the private sector for CADE to consider environmental aspects into the analysis of horizontal agreements, that is cooperation between competitors, okay? And in those cases, CAGI tends to look to what the European Commission does, because the European Commission has updated its horizontal guidelines to include a chapter on sustainability agreements, right? So pretty much what we have is CAGI does not have its own horizontal agreement, and it is not taking cases specifically related to environmental factors, but in horizontal cases, it tends to adopt an approach closer to the EU, okay? So having that context in mind, I was wondering, should we, in Brazil, copy pretty much what the European Commission is doing? Or could we think about other possible approaches other than horizontal agreements, for example, to combine or to find intersections between competition law or sustainability? I'm not defending necessarily that competition law should do this, but if we are to do this, why not to consider other approaches other than just horizontal agreements, right? So these led me to my research question, which is, are the approaches adopted by competition authorities comprehensive of the possibilities indicated by literature regarding intersections between competition law and sustainability? Which other paths could be explored? To do that, I kind of divided this research question into three other questions, maybe. So first, how did we get here? So the origins of this debate, to identify the factors that contributed to renew the interest in this debate in recent years, and also factors that possibly have influenced the shaping of the approaches adopted, mainly the approaches toward horizontal agreements. Second, I'm trying to understand what here and now looks like. So I'm trying to draw a comparative overview of what is being done right now. So guidelines and cases handled by authorities all over the world. And finally, how can we move forward? So which are other possible approaches other than horizontal agreements, including, for example, enforcement of abuse of dominance cases, investigations, or merger review. So how I'm doing this, and this is the methodology I am using. So first of all, regarding origins and development, I am doing document analysis and literature review. I would like to share with you two findings so far. The first one is that this discussion dates since at least the 90s, even though most recent guidelines and the renewing interest in this debate dates from 2019 around. And since the 90s, horizontal agreements were already the focus of cases and guidelines. So this may explain a little bit this focus as well. And the second finding is that I have identified some factors that may have contributing to renewing the interest in this debate. These are, of course, pressure from the private sector, debates on the goals of antitrust, but also government directives. And that may sound obvious to some of you, because competition authorities can be considered in many countries part of the executive power, but that's not necessarily obvious because in Brazil, for example, we don't have that. So the government is not pushing the authority to come up with guidelines or something to comply, for example, with an agreement, an international agreement. And as you can see, I draw here the example of the Netherlands. In green, you can see actions by the government or the ministry asking ACM to do something or to take measures regarding environmental or sustainability. And in light red or pink, you can see actions actually took by the ACM, okay? So when we put that into a timeline, it's pretty much drawn this factor as influence as well. Once again, I'm not saying this is a problem. I'm just reflecting on if we don't have government with the public policy telling us to do something with a certain like end in mind, should we just copy what other jurisdictions do out of like best practices? So that's my question. To conduct a comparative overview, here's where I am right now. I'm looking through the guidelines and then I'm going to go through cases. First, of course, I had to find which are the guidelines that exist. To do that, I've mapped 146 competition authorities. That means OECD members, OECD key partners, and also ICN, International Competition Network members. I've looked into the websites of these 146 authorities, of course, in the sections for guidelines, but also with keywords, mainly sustainability, environmental. I've looked for that in English, Spanish, French, and Portuguese in these websites. What I could find, and I did a double check with GCR, MLX, and Concurrence reports. What I could find were 14 jurisdictions with guidelines and 19 relevant guidelines. Why do I have more relevant guidelines than jurisdictions? Because the European Commission, for example, has a guideline specific to the agriculture sector. So there's more than one. And also I'm considering documents, guidelines that are not in force right now, but are relevant to tell the story. That means another 3 guidelines from the Netherlands and the EU horizontal guidelines from 2001 that had a chapter in environmental agreements, and right now the chapter is on sustainability agreements, which is already a difference between these two. Then I draw some questions in order to be able to compare these guidelines. What I have is a spreadsheet. I'm not showing you the spreadsheet because it's not pretty. I just listed the questions I'm looking into. Basically, general info. So guidelines, do they apply to sustainability or to environmental sustainability, which is a difference? Do they have provisions on horizontal agreements? Are there exemptions? How to qualify for an exemption? Are there safe harbors below a certain market share? Are there provisions on vertical agreements, abuse of dominance, that is exclusionary and exploitative practices? On mergers, are there differences between horizontal, vertical, and conglomerate? To be honest, I'll probably add more questions, but for right now, I haven't identified guidelines with those so far. That's why I don't have questions within those categories yet. And procedure info. So are there consulting mechanisms with the authority? Are there formal and informal? Is consulting binding or not? So we can have an overview of what is being done. As to the next steps, I intend to conduct a pretty similar approach towards cases. I still have to define which cases and exactly which jurisdictions once I get there. And then finally, I hope to be able to answer my research questions. So are the approaches comprehensive? What are other paths that we can take moving forward? So that's it. Thank you very much, Professor Thibault and Georgiana, for having me. Thank you very much for your attention. Look forward for critiques and comments.
Max, you're the very last to challenge one of our speakers today.
Yeah, thanks for your presentation. Very clear why there's a necessity to do this. But you say in one of your in the beginning of your presentation, you said you're going to look at, I think I wrote it down correctly, not why we should do this and how we're doing this, the environment impact assessment of whatever you want to call this. But isn't it the question that we should ask for? To what extent should competition law do this, and what extent should we incorporate this before asking the question how we're going to do it? And that should be, I think, more at the start to understand what are the different paths that we should take that you knew at the end of your at the end of your presentation, and to what extent you agree with that or not agree with that this should be beginning for read.
Okay, thank you, Max. So yeah, of course, I think the debate on whether we should or should not consider this is a very important one. I think it can vary a little bit depending on the jurisdiction, on the law we have, and the interpretation we have of that. What I wanted to say is, I think in Brazil, this debate is possible, as I showed you, based on the constitution. That means that at least there, when I'm most comfortable of saying that as a law perspective. If the debate is possible, it's pretty much a discussion of public policy, as I see, especially consider that the competition authority is part of the federal government directly there. So I think it's possible. If we're defending if we should or not, I think this is a debate on what do you want to promote, and that what bothers me so much about just copying what with whatever like other countries or jurisdictions do. Because if we don't have a project of public policy as I mean the government as a whole, why should we just copy like best practices? Because it is best practices to do this without questioning other approaches we have. So that's why I wanted to start showing a real case of our reality as well. Because when we go to real cases, we sometimes see, as I showed you, a case of a merger review or abuse of dominance, for example. It could be framed that way, maybe. Um, and other horizontal agreements. So I don't mean to say that horizontal agreements are not important as well, but why should we just assume they are? Because that's practice. Told us they are, you know. But I think that question is very important. But where I struggle with that is I think both ways are possible. So yeah, thank you.
Yeah, thanks. Super interesting to get the Brazilian perspective. My question, in a way, ties in with Max's, because as my contribution, I'd like to ask you about the role of the objectives of competition law. You listed them as a relevant factor, but then in your comparative methodology, they weren't really reflected in the question. Whereas I think, especially in this comparative debate, it is interesting to look at the roots of the different regimes, because that may very well impact how sustainability related considerations are perceived in the system. Is this something you took into account, or could this be a perspective that is also interesting for your research?
Yes, if I understand correctly, yes, I do think so. But I mean, um, Brazil is part, for example, of many of the conventions and international agreements, such as the EU, for example. So there would be grounds to say, okay, we're pursuing the 2020, the 2030 agenda, for example, the Paris Agreement, or we could say that as well. But this is not happening there. I mean, the government is not requiring the antitrust authority to cooperate, and there is no a specific target on doing that. So I think yes, this all these principles could be there, but there's not like a public policy well framed. I think that's what's missing. And I think yes, this is a very important part. And I think I am trying to address kind of this question here, saying that other countries do this not only because their law provide space to do so, such as ours do as well, but because they have like a policy. Whether this is a good policy, well structured enough, I don't know. But it seems to me that there is a direction. It's different from just like, let's see what other competition authorities are doing, as if they were producing, for example, vertical guidelines on how to review, like vertical mergers. I think there's a difference here. I don't know if I answered your question.
Steve. Yeah. Well, I think three things I'd like to commend you about is that. Well, first of all, I really like the way you started from the broader perspective, more constitutional perspective, because I think that's important. That also ties into the question line, because competition law is in Brazil, as I understand, part of this broader constitutional system, as it is also in the EU. I think so. In that sense, I can relate. So I think that's very interesting. So you put the broader constitutional perspective. What you what's interesting that afterwards she said, "Well, I'm not going into why," whereas I was thinking, I understand why, because of the border constitutions. Next, I think it was very structured, very logical. It's very easy to follow you where you were going. And then last, I really admire you that you had the stamina to check 146 different of authorities. So well done.
Do we have questions or comments? Go ahead.
I do have a question and a comment. This is an area where I've been at it both on the public policy side with the ACM, and I'm also trying to research it on the academic side as well. And I have to compliment you for your effort, because I was only able to find the EU, a couple of member states, the UK, Japan, New Zealand, and Singapore. It struck me that they all had pretty much the same approach, where they didn't go into the objectives and principles so much, and they adopted a more practical approach where sustainability is seen as something that can be an interest that plays a role in the competition rules in terms of things like quality and choice. And then the main debate has been about the fair share for consumers and whether or not collective benefits can be taken into account. And we've sort of sidestepped, certainly in the EU, the constitutional dimension and the question of whether sustainability is an objective under competition law. I think you can have a debate about that, but it's certainly also possible to sidestep that and simply pursue it under competition law within the constraints that I've just mentioned. And I'd be interested in your findings or intuition about whether there are alternative paths, because it would seem that mainly in the Brazilian context, you would probably have this, or be able to have this constitutional discussion where you might end up balancing between different objectives, because your constitution allows you to be, but mainly required you to do that. But my question would be, what do you think that would mean in terms of, in practical terms, for the scope of what would then happen under competition law? Could it necessarily be very different? So even if you don't start by simply copying the approach that is out there, which is remarkably similar between these different jurisdictions, would taking a different starting point necessarily lead you to a different conclusion?
Okay, thank you very much. These are interesting questions. Yes, I think it would lead us to a different conclusion. I think it may be hard for a competition authority to balance between like competition law and other aspects. Maybe this is more to courts to do, maybe. But I do think competition authorities could take other paths. For example, they could start investigations into market sectors. They could target companies. I think there are many other ways to do that other than just putting out guidelines for cooperation. I think this is a possible approach, and if the approach is well designed in other companies, we should save time and resources by just like looking at what they did, and we can implement as well. That's not a problem. But I think this is a restrict approach. So I think much more can be done, especially through studies and through investigations, and also mergers, I think, to a certain extent, which is something like courts in Brazil do not review. So I think competition law, of course, they may review CADE's decision, but CADE is the first instance to take any merger that should go under merger review. So that's a whole play. It can play as well. Yeah, but that's it. I'm not sure we should do this, but if we are doing this, there are other.
I totally agree. You could do something under merger control and use the dominance, but would it be very different though? Because if you do that under the efficiency defense in both cases, then it's going to look very similar to what we already happened in the horizontal agreements. For at least adjusting, it would be something different.
Like if you were investigating something under like for illegal behavior, that's different probably during cooperation necessary.
No, but you would have that. The efficiency defense essentially applies across all three instruments of competition law. And then you already have an approach for that under horizontal agreements, which you could apply to vertical agreements, could apply it to these cases or to mergers.
Okay, but we don't have action, right? We don't have investigations. That's what I mean. So maybe we can apply the theory, there is in the guidelines, but we don't have like actual action into taking those cases and these studies into applying that theory to an abuse of dominance case, to a merger review. We don't have that.
One last question.
Georgiana, yeah.
Thank you so much. And I was wondering whether some of the questions that you are asking about why authorities elsewhere in the world do this and why should the Brazilian authority do this? I was wondering whether they might lead you more into a legitimacy debate. Because that seemed to be where you were going with the idea that there's not a broader policy from the government to inform how the Brazilian competition authority should shape integrating sustainability concerns. So maybe that could be to legitimacy problems for the guidelines if the guidelines just seen this. Well, if they're seen as law that's not coming from the legislator sense.
So we're coming back to the same first comments, right? It's not that in PhD you necessarily want to say whether it's a good idea, but what the law enables agency to do actually impact how they do it. All right, is that, in a sense, the essence of many of the comments? All right, on that, thank you so very much, Stephanie, for a great presentation.